This is Duke University.
Hello, everyone. Thank you for coming. Welcome to today's Federalist Society event, a debate on healthcare between the Honorable Greg Katsas and Professor Barack Richmond. Y'all can join him, or you can just leave him out
for
there.
him?
I got one vote.
You'll notice at your desks there's this brief survey. The blue portion they want you to fill out before we get going here, and the yellow portion after you've heard the debate. And then as you exit, there will be someone collecting the surveys at each exit. I believe the pens are yours to keep. The polling company will get mad at me if that's wrong, but oh well. You know me, I don't do introductions very well, but Professor Barack Richmond, here to my left, his research interests include economics of contracting, new institutional economics, antitrust, and, why he's here today, healthcare policy. He teaches contracts, antitrust, and health law in his guest taught classes at the Fuqua School of Business and the Stanford School of Public Policy. He was invited to the Yale-Stanford Junior Faculty Forum in 2004, received the Duke Law School's Blueprint Award in 2005, and was a recipient of the Provost's Common Fund Award in 2006. I'll stop there. The Honorable Gregory Katsas is currently a partner at Jones Day. He's argued more than 40 appeals and has won more than 30, and has argued in every federal appellate court, including the United States Supreme Court, including the first day of oral arguments on the Affordable Care Act in March. Between 2001 and 2009, Greg served in many senior positions in the U.S. Department of Justice, including Assistant Attorney General for the Civil Division and Acting Associate Attorney General. In these positions, he handled or supervised most of the government's leading civil appeals. He's done a few cases of his own, including important topics such as the detention of enemy combatants at Guantanamo Bay, the use of national security letters in major counterterrorism investigations, the applicability of the state secrets privilege in litigation about covert CIA activities, the closure of immigration hearings for suspected terrorists, and the constitutionality of federal statutes, including the Affordable Care Act. With that, I'm going to turn it over to Mr. Katsas. I hope you enjoy today's event.
Thank you. Thanks for having me, and thanks for such a great turnout. I thought what I would do is just sketch out for you the basic position that we presented to the Supreme Court last week on the constitutional challenge to the Affordable Care Act, and then maybe talk a little bit about the case more generally. Affordable Care Act is obviously a very large and complicated statute, but the constitutional challenge focuses on one very specific provision, the individual mandate, which is a requirement that every American citizen essentially maintain health insurance beginning in 2014. We think that presents a novel and important question whether Congress has Article I authority to require people to buy goods and services that they don't want. The government has asserted three different justifications for the individual mandate in, I think, decreasing order of importance and plausibility. The Commerce Clause, the Necessary and Proper Clause, and the Taxing Authority. So I'll just say a couple of words about each of those. The Commerce Clause is the power to regulate commerce among the several states, regulate interstate commerce for short. The text of that clause talks about regulating interstate commerce. We think that plausibly means one of two things. Either Congress can prohibit commerce interstate commerce that it doesn't want, and federal drug laws are a classic example of that, or to use the formulation of Chief Justice Marshall going all the way back to Gibbons versus Ogden, the first Commerce Clause case. Congress can prescribe the rules for carrying on commerce. So just to take some obvious examples from the New Deal era, Congress can say that if you're a buyer or seller of labor, the rate has to be a minimum amount. That's a minimum wage law. Or to take the classic civil rights era Commerce Clause examples, Congress can tell people who run public accommodations that they have to take all comers regardless of race and sex and religion and so on. It's prescribing the rules for commerce. But both of those are very different from what Congress has sought to do here, which is force people into commerce. Take people whose defining characteristic is that they don't want to purchase the product in question, which is health insurance, and force them to do so. And we think that that can't plausibly be described as regulating interstate commerce. It's forcing people into commerce so that Congress can regulate them, and I'll explain more in a minute why Congress wants to do that. That's the textual argument. It's backed up very strongly by history because it turns out that literally never in American history has Congress sought to use its Commerce Clause power to force people to buy unwanted goods and services. And that's true even though this would be an incredibly attractive power and an incredibly direct means of stimulating an economy. So one of the principal problems facing the framers was how to stand up a national economy. And Alexander Hamilton, a great advocate of national power, writes his report on manufacturers, speaking about all the different things Congress can do to stimulate a national economy. Well, what better thing to do, if Congress could, to stimulate the economy than to simply force people to buy things, whatever product markets Congress wanted to stimulate, and yet Hamilton doesn't even conceive of this as a possibility. Or fast forward to the New Deal, Roosevelt is president, there's an activist Congress, the country's mired in a depression, obviously there's a desire to get the economy moving, and yet it never occurs to the New Deal Congress or to President Roosevelt that they should just force people to buy things. Again, a pretty direct way of stimulating the economy. Those points have not just historic interest, but legal interest, because the Supreme Court has said that if there is an alleged power that's lain dormant for more than 200 years of our constitutional history, despite its seeming availability and attractiveness, the dormancy is itself a pretty good reason to conclude that the power doesn't exist. So that's the historical argument. We have an argument based on precedent. I'm just going to mention one case, which is the famous case from the 40s of Wickard against Filburn. This is the farmer who wanted to grow a little bit of extra wheat to feed his family. Unfortunately for the farmer, he was subject to a wheat quota imposed by some New Deal program designed to limit the supply and therefore prop up the price of wheat. He challenged the quota. He said, I'm not engaged in any commerce. I'm not selling the wheat. I'm just growing it and consuming it on my farm. And I'm also not engaged in anything interstate. I'm just doing something on my farm. There's nothing crossing any state lines. And the court in the early 40s, at the height of its pro-federal government power, says doesn't matter, good enough for government work, and it creates this substantial effects doctrine, which is that even though there's no commerce here, the farmer is engaged in what later cases called economic activity, and the court says, although no one instance of that activity may substantially affect interstate commerce, if every farmer in the world situated similarly to Filburn were allowed to grow extra wheat in the aggregate, all of those production decisions would substantially affect interstate markets, and that's enough to support the regulation. So that's as far as the court has ever gone. You can see how expansive it is. There's clearly a fudge on interstate, and there's a fudge on commerce, diluting commerce to economic activity. But even Wickard is far removed from what we have here, because here we don't have people who are engaged in economic activity. We have just the opposite. We have non-market participants who are told that they must buy the good in question. So the analogy to Wickard is not telling someone who's a supplier in the market you can't produce more than a fixed amount. The analogy to Wickard would be if the New Deal Congress had told Farmer Filburn's neighbors that they have to buy his wheat. Again, seemingly obvious way to meet the goal of propping up the price of wheat, not something that Congress ever did and not something that the Supreme Court has ever approved. So we have a case of first impression, Congress going beyond anywhere they've gone before in Commerce Clause legislation, and we think a very slippery slope. If Congress can do this with respect to health care, query what they can't force American consumers to buy. Why do I say that? Well, the doctrinal question here is how to apply the substantial effects doctrine from Wickard to non-purchase decisions. It will always be true that a market with millions of people forced into it as a result of a federal purchase mandate will be substantially different from a market without such a mandate. So in a sense, there is the requirement to buy the good has a substantial effect on interstate commerce. If that's good enough for purposes of this Commerce Clause analysis, that has nothing to do with health care. It's going to be good enough for any good and service that Congress may choose to require people to purchase. So at least under conventional Commerce Clause doctrine, if the government's argument works for health insurance, it works for anything. And we have the prospect of Congress using purchase mandates to replace what had been a more or less free economy up to this point with a command and control economy. Unless you think that's the hyperbolic exaggeration of an advocate, in the case, I will tell you that those very words, the specter of the command and control economy, were not something conjured up by me and my team. That was the exact phrase that the Congressional Budget Office used in 1994 in flagging problems with the health insurance mandate associated with the Clinton-era health reform package, which was proposed but ultimately not enacted. So that's our Commerce Clause position. There's a separate argument under the Necessary and Proper Clause, which runs roughly like this. There are other provisions in the Affordable Care Act that are legitimate regulations on interstate commerce. The most important ones for purposes of this argument are called guaranteed issue and community rating. Guaranteed issue is a requirement that all insurance companies must take all comers, no matter how sick, no matter how high their individual risk. And community rating is the further requirement that insurance companies have to charge all of their insureds the same rate, regardless of their individual actuarial risk. What happens if you have guaranteed issue and community rating without a mandate? Well, what Congress thought, based on the testimony it took, was that there would be huge upward spiral on premiums. What happens in this system? Low-risk people who are forced to buy at average rates. That's a bad deal for them. They opt out of the pool. Insurance companies are forced to insure high-risk people at rates that are a bad deal for the insurance companies. They lose money on the high-risk people. They can't make it up on the low-risk people. The pool gets riskier. The rates escalate. And according to one of the key witnesses who testified before Congress, there's not just an upward spiral, there is what the witness called a death spiral. So Congress imposes the mandate for the avowed purpose of forcing low-risk individuals into the health insurance pool at rates, at bad deal for them, in order to subsidize the insurance companies who are losing money on the high-risk individuals, or you can think of it as forcing low-risk individuals to subsidize high-risk individuals in the insurance pool. And they say this system won't work without an individual mandate, and therefore they argue that the mandate is necessary and proper in order to support the guaranteed issue and community rating regulations, which on our view are legitimate Commerce Clause regulations. They're not forcing people into a market, they're just conditions on doing business in the health insurance market. So that's the argument. What's wrong with it? Well, in our view, this is really different from past typical exercises of necessary and proper clause. One classic example of necessary and proper clause is something like a record-keeping requirement. Congress passes a rule, they want to make sure that the rule is enforceable, so they require you to keep records to make sure that you're complying with the rule. It's just one example, but here, think about how different this is. There's no problem of non-compliance here. There's no problem with the guaranteed issue and community rating provisions being carried into execution, which is the phrase from the necessary and proper clause. The problem is that once those requirements are fully executed, it turns out the burdens on the regulated parties are unacceptably or unsustainably high. So Congress then is trying to dragoon strangers to the regulated market into the market to offset the regulatory costs. And this kind of offsetting power we think is equally novel and not supported by any necessary and proper precedent that we're aware of. It also seems to create some pretty perverse incentives. If Congress can kind of leverage its own power, the more dysfunctional a regulatory scheme, the more power Congress acquires to counteract its effects. And it also seems equally limitless. Just to take a couple of examples, back to Farmer Filburn, he is hurt by a federal regulation limiting the amount of wheat he can produce. Can Congress compensate him by forcing his neighbors to buy his wheat? Or to take an example from the Civil Rights era case, the restaurants and hotels in the South in the 60s who were subject to the anti-discrimination laws opposed those laws, at least in part on the ground that they would lose business. If they were forced to take all comers, many of their clientele wouldn't care to frequent integrated restaurants. So restaurateurs are losing business. Can Congress offset that cost by forcing the rest of us to go eat food in restaurants? Or to take an example from the Affordable Care Act, as I've described it, this whole system is designed to provide subsidies to high-risk individuals who might otherwise have trouble getting insurance. Can Congress mitigate the regulatory costs that those folks impose on the rest of the system by forcing them, or forcing everyone from that matter, to purchase all manner of healthy products? This is the famous broccoli and gym memberships and everything else. If this theory of offsetting works, it's hard to see why they wouldn't have that power. So that's our objection to necessary and proper, sort of similar to commerce, unprecedented, potentially unbounded. The government's last line of argument is that the mandate can be justified as a tax. That, I think, is their most difficult argument because the mandate is simply not structured as a tax. The mandate is a legal requirement to buy health insurance. It's backed up by a penalty payable to the government as a result of a violation of the legal requirement to buy health insurance. And the cases addressing the government's taxing power give the government a lot of leeway, but all of those cases distinguish between taxes and penalties. It's a pretty intuitive distinction. A tax is an exaction, a requirement to pay the government. It's imposed on a lawful activity in order to raise money to support the government. So the government allows you to sell cigarettes and imposes a $5 a pack tax. No one is violating the law by selling cigarettes. It's just a lawful activity that triggers a tax. That's different from a prohibition backed up by a penalty, which is the government says you may not sell cigarettes. If you sell cigarettes, you pay a $5 a pack penalty. Economists like to say that those two formulations may be equivalent, may or may not be right in economic terms, but in legal terms, the court's tax cases have distinguished between the two time and again, and the mandate is structured as a requirement backed up by a penalty, in contrast to many other provisions in the Affordable Care Act that are structured as taxes on voluntary activity. That's our position in a nutshell. I think one confirmation of how far we've come in the case is that at the beginning of the case, the government would have disputed quite vigorously everything I just said. Now, not so much. They have more or less acquiesced in some of my points and offer only tepid opposition to others. Their basic response is to say, well, all of that may be right as a general matter, but health care is different. And they say health care is different because of a variety of features of that particular market. They say health care is very expensive. No one knows when they'll need it. When you do need it, you can get it for free. So if you're uninsured and go into an emergency room and can't pay for your care, the docs and the hospitals have to eat that cost, and it gets passed on to other people who are in that market. That's kind of the nub of their position. So just a couple responses to that. One, it seems to us a little bit ironic that the government is invoking concerns about cost shifting to justify the statute, because the whole theory of the mandate is to justify the cost shift from the low-risk individuals to the high-risk individuals in the insurance pool. And if you try to measure relative effects, that federally compelled cost shifting dwarfs the cost shifting that happens in emergency rooms. But more to the point, the government's distinctions seem to us not really clean and sharp ones factually. At most, they're ones of degree, and they don't particularly distinguish this market all that sharply. There are lots of events in life that are unpredictable. One buys insurance not only to cover health costs, but disability, fire, flood, you name it, and the government's arguments at a minimum wouldn't distinguish any kind of insurance. The idea of cost shifting, this is cost shifting that happens when people buy goods on credit and then don't pay for them. But that's not unique to healthcare. The government made a point of sort of poking fun at one of our plaintiffs who went bankrupt and failed to pay about $4,500 in unpaid medical bills. And that's true, and it's unfortunate. But what they didn't tell you is that this plaintiff also had $45,000 in other unpaid bills to everyone from the landlord to the cable company. Goods and services bought on credit. If people can't pay for them, the supplier is left holding the bag, and the costs are spread throughout that market. So the cost shifting phenomenon doesn't seem to sharply distinguish healthcare, nor does the fact that healthcare is provided for free. Most modern societies, including ours, provide all manner of goods and services to needy people who can't afford them, not only healthcare, but food, clothing, shelter, legal services, education, on and on. So the government's factual distinctions don't seem all that sharp to us, and their legal distinctions, none of this seems relevant in any obvious way to the governing doctrinal questions, which I discussed a couple of minutes ago, whether the government has this sort of offsetting power and how you apply Commerce Clause doctrine to non-purchase decisions. Now, you might say to yourself, well, the Supreme Court is the Supreme Court. They can change the law. They can draw any lines they want, so why not take these economic and empirical distinctions such as they are and convert them into constitutional ones. The problem with that is, suppose the court does that, what happens with the next mandate and the next and the next when the government asserts a different important interest and a different reason why they really, really need to kind of force people into some particular market? One of two things is going to happen. Either the court will just defer to Congress's assessment of its important interests and how the economics work and why they need the mandate, in which case the slope will, in fact, be pretty slippery, or they won't, in which case the court then will be engaged in some form of heightened scrutiny under the Commerce Clause itself, trying to distinguish health care from mortgages, mortgages from cars, who knows what. That's something they're not particularly good at doing. It's something they don't particularly like to do. And we think it would be far preferable for them to adopt just the clean, bright line rule, no purchase mandates, that doesn't put at risk any existing federal statute besides the Affordable Care Act, and it doesn't force them to go down this road of trying to distinguish market from market based on economic considerations beyond their expertise. That's our position in a nutshell. I'll just tell you 2 minutes about the arguments last week. It would not be an exaggeration to describe the case as historic. Supreme Court took a single 4-issue case and converted it into 4 cases. They separated out 4 different issues for separate briefing and argument. Everything I just told you about the constitutionality of the mandate was simply one of 4 issues, was argued for 2 hours on Tuesday. That was preceded by a separate 90-minute argument, which I had the privilege of participating in, on the question whether a federal statute called the Anti-Injunction Act bars review of our challenge in a pre-enforcement context. And then there were 2 separate arguments on Wednesday, one a 90-minute argument on severability, what happens to the rest of the statute if the mandate falls. We can go into that if there are questions. I won't do it now. And finally, a separate constitutional challenge to the Medicaid expansion brought by the states under the spending clause. This is the question whether there are any limits on Congress's ability to attach strings to federal funding. That in and of itself is an unsettled and very important question. 6 hours of oral argument in toto. That's the longest argument in at least 50 years. We obviously had a huge amount of interest in it. Case is under advisement. I'd be very surprised if we saw anything from the court before the last week in June as the term winds down. Probably not anything until the last day in June. So we are eagerly awaiting the court's decision. We're happy with how we presented the arguments, and we'll just wait and see what they do with the case. Let me turn over the floor.
Great, thanks. So first of all, I want to commend Greg for somehow or another sabotaging my pen. It's remarkable that his rhetorical abilities are amazing. So thank you. I'll just get another one here. All right. I have a couple very basic points to make. The first point, which is the most important point, is that 2 weeks ago, when the oral arguments took place, it was a very good week for Greg Katsas. It was a very good week for Paul Clement. It probably was a bad week for Don Verrilli. We were talking actually earlier about how after oral arguments, everybody evaluates the performance of the advocates and nobody evaluates the performance of the court. Well, it was a really bad week for the Supreme Court. The Supreme Court did not look good. It was a bad week for constitutional law and, frankly, a bad week for the Constitution. I might even say it was bad for our separation of powers. The Supreme Court did not show itself well. Now, this is not, you might say, the first time the Supreme Court has made this kind of mistake. That is, using its own legal analytical template into a very complicated regulatory scheme. In fact, I brought a little prop. I'm going to play a clip, a very short clip, of Senator John McCain's comments after he saw the Supreme Court's oral arguments in Citizens United. Citizens United was the constitutional challenge against the McCain-Feingold legislation. McCain-Feingold was a very, like PAPACA, a very complicated, long regulatory bill that tried to organize and regulate campaign contributions. Let's see if I get this right.
Went over and observed the arguments, the questions that were asked, the naivete of the questions that were asked, and the arrogance of some of the questioners was just stunning. And the questions they asked showed they had not the slightest clue as to what a political campaign is all about and the role of money that it plays in political campaigns. And I remember when Russ and I walked out of there, I said, Russ, we're going to lose. And it's because they are clueless.
It's actually really sad. It's sad that there are multiple layers to that comment. Number one, it's sad that you have the highest court in the land really showing its ignorance in a certain policy area. Frankly, I think that the court's role in regulating democracy, which is essentially what campaign contributions is about, is probably more justified, is more justified than regulating a very complicated economic framework. But nonetheless, what is not justified is not grasping the very facts and basic economic and legal forces that underlie both the legislation and the industry that the legislation is designed to regulate. My favorite example is this. Justice Scalia, on the third day, said quite confidently that the argument was this is about severability. And the government said, look, you got to be able to sever a lot of this bill. For example, we have certain provisions already in force. The requirement to allow families to include their children under age of 26 in their insurance plans. That's current law, and that's happening right now. And Justice Scalia says, well, without the individual mandate, that's going to bankrupt the insurance companies. At pretty much exactly that moment when Justice Scalia was asking that question, my health law and policy course was hearing from the head of HR for Duke. And he was telling us what the financial impacts of these regulatory rules were. And he said, we've had to take under 26, and it's increased our overall cost by about 2, maybe 2.5% of our expenditures. I don't know whether to be more surprised or outraged at the fact that Justice Scalia is profoundly wrong, as a matter of facts, or that he's incredibly confident in his presentation of facts. This is not judicial deference. This is not judicial humility. Judicial deference sometimes means adhering to precedent, but precedent gives and precedent takes, and that's a much harder judicial ideology to describe, that is adherence to precedent, because there's always another precedent to support your current view. But I think judicial deference is extraordinarily important when you have to understand that there are certain things you just don't understand. Or better yet, there are certain policy features that courts are not good at intervening in. And a complicated regulatory scheme like this is probably front and center, the most obvious case where the court really has no role and constitutional law really has no role, and the court should know the limitations both of the institution of the Supreme Court and of constitutional law. So let's get to constitutional a little bit. To some degree, you can't blame the Supreme Court for looking at legal distinctions that constitutional law, you might say, encourages them to look at. Now, incidentally, Greg and his colleagues have done a remarkable job of controlling the rhetoric of this debate. And the rhetoric that they have created months ago, about a year and a half ago, really was the rhetoric that you saw at the Supreme Court. Part of that is because they were just really good, and they put words and ideas in people's heads, and that's the way people have been thinking about it. Be careful. How many times did he use the word force? I'm serious, force. We're going to get to that. But the other thing is that the constitutional questions, the constitutional distinctions, that you might say they are forced to ask are just inapposite. They're not applicable. The fact is that the individual mandate is a very benign idea. It's been around for a long time. It was first proposed by the Heritage Foundation, which I think is to the right of the Federalist Society. It was constantly trumpeted as the alternative to Hillary Care. Senator Don Nichols, no moderate himself from Oklahoma, proposed it, and he got 25 Republican senators to sign on to it in the 90s. Former minority and majority leaders, Senators Baker, Dole, and Daschle, 2 Republicans, 1 Democrat, suggested that the individual mandate is the best way to go for insurance reform. Senator Chuck Grassley, the ranking Republican in the Senate Finance Committee, the committee that had primary jurisdiction over this bill, said that an individual mandate was a really good way to go as recently as 2009. This just isn't a big deal. It's not a big deal. It's not an intrusion on anybody's freedoms. It's actually just a very reasonable, very moderate, to the degree that it's to one side of the ideological spectrum, it's probably to the side of the right, approach to regulating a very complicated market. Individual mandate is all about individual responsibility. That's why it was appealing to Republicans. That's why it was appealing to the Heritage Foundation. It also is appealing to lots of healthcare policymakers, healthcare policy scholars, because it's reasonably workable. So you have something that is politically appealing to members of the center and right political spectrum, at least up until 2010, and that is reasonably workable among policy and policy experts. And now suddenly it's unprecedented and limitless power grab. I just don't get it. But the reason I don't get it is because the Supreme Court doesn't get it. They're asking the wrong questions. This is just nothing more than a moderate response to a very difficult problem. Incidentally, the difficulty and the severity of the problem is something I'm going to close with. And this I'm going to be echoing stuff that other people have heard me say before. So I want to talk about 3 things now. I want to talk about this word force. I want to talk about the command and control comment that came out in 1994. Actually, it came out before that. And then I want to talk about the deep tragedy that we are now witnessing. All right. Force. Greg used the word force a number of times. The Supreme Court used the word force a number of times. He kind of threw a nod to economists in saying that, it's kind of hard to determine what the difference is between a $5 tax and a $5 penalty, or better yet, a negative tax a tax credit that is taken away. There's a reason that economists think these are all the same. It's because they are the same thing, and not just economists think that. Now, the paradigmatic example, the perfect utilization of the Commerce Clause, Greg said, and everyone agrees, is the regulation of wages. Surely Congress has the authority to regulate wages. You think the guy who's sitting on his couch watching television unemployed is not affected by wage regulation? Of course he is. He's deeply affected by it. In fact, he's affected by it more than anybody else. The more you regulate the labor market, the more you intervene, the more rigidities you put in, the harder it is for this guy to get a job. The distinction between those who engage in commerce and those who do not is a false distinction. And forcing people to engage or buy something versus forcing people or not forcing people is a false distinction. This is the way the Supreme Court thinks, and it's all the more reason for the Supreme Court to stay out of this altogether, unless, of course, they approach it a little more intelligently. When we have a comprehensive regulatory scheme, and healthcare in this country is as regulated as anything, as any other industry. And insurance is thoroughly regulated, mostly on the state level, but also on the federal level. And there's a reason for this, not necessarily good reasons. And frankly, I'd be the first to say that we have to remove a lot of these regulations. I think that they really are significant contributors to our overproduction of health, of the spiraling costs. But we have a complicated regulatory scheme throughout this industry. And to think it's the individual mandate, which incidentally, the individual mandate, that's also a rhetorical ploy. All it is saying, look, if you want to remove yourself out of the system, you have to pay an approximation of the cost that you're imposing on everybody. They call it a mandate. I mean, I don't know if you call it a penalty or a tax. It doesn't matter. The point actually is that it's really small. You actually run the numbers, and I think that PPACA is going to produce more uninsured than insured because the penalties are too small. I mean, you can call it a penalty still, but the constitutional analysis often looks at whether or not there is a penalty and whether you can call it a penalty. Those are absurd questions. The question is what kind of incentives it imposes on people and whether or not this is meaningfully going to shape the marketplace. And it's not. The numbers are too small. In fact, we talk about the employer mandate that was imposed that was suggested by Hillary Care. This bill has an employer mandate, although they don't call it an employer mandate. They call it a pay or play. It's essentially the same thing. Either you cover insurance or you pay something. And the individual mandate, either you purchase insurance or you pay something. These are very, very nominal, very insignificant, and fully precedented interventions on commercial markets, especially commercial markets that have a long, long history of being thoroughly regulated. Now, what about this command and control? This is what I'll call my next point. This is the point that I think is my clincher. This point will tell you that constitutional law makes no sense in this area, although maybe in no other area either. Is Medicare constitutional? Now, if Greg wants to launch an attack on Medicare, I actually might sign up. That is a government takeover. That is a real imposition. That is a command and control model of regulating healthcare. I have not heard any constitutional challenges in the 50-some years almost 50 years that Medicare has been around. Tell me what makes sense if an individual mandate is found to be unconstitutional, essentially a small addition to a thoroughly regulated private market. But Medicare, which really is a government takeover, is not. That makes no sense. And how can you rest your laurels on constitutional logic? That makes absolutely no sense. Now, there was a great conservative figure when Medicare came out. His name was Ronald Reagan. And he said, this is the end of our freedom. And now we have a successor to that Reagan tradition. His name is Rick Santorum, and is calling it, this is the end of our freedom. Well, needless to say, Rick Santorum is no Ronald Reagan. But Ronald Reagan actually has a point here. Rick Santorum does not at all. And there actually is a serious point here. And this is actually, that was a serious point. There's another serious point. This is my segue to my last point, which is the real tragedy here is that we, America, have lost this rhetorical battle. We're talking about forced purchasing versus unforced purchasing, or activity versus inactivity. Just stupid distinctions. In fact, actually, to paraphrase George W. Bush, paraphrase loosely, a constitutional challenge to PPACA never cured a patient, never reduced a hospital bill, never helped the uninsured. Of course, George W. Bush is talking about a med-mal suit. And he has a point. It's a small one, but he has a point. But these legal challenges really do nothing to help what really is a very, very severe problem. We should not be talking about inactivity versus activity. We should be talking about fiscal stability, sustainability. We should talk about the fact that we're spending 18% of our GDP on healthcare, which is 1.5 times more than the number 2 nation, that we have worse health than everybody else, that we are driving businesses, incidentally, including many that are represented by Greg's employer or client, NFIB. Businesses are being driven to bankruptcy. The federal government, because of Medicare, is being driven to bankruptcy. We have a severe, severe problem. We should be talking about alternative solutions. We should be talking about Paul Ryan's Medicare reform. We should be talking about the Baker-Daschle-Dole alternative to PPACA. We should be talking about how we can stem rising healthcare costs. That is what we should be talking about. I take the Federalist Society, I told Phil that I take this Federalist Society to task. They're having us talk about the wrong thing. There are a lot of very conservative, very good ideas out there that we should be talking about. And this is not one of them. NFIB was largely responsible for defeating Hillary Care in the 90s. Kudos for them. They engaged in the democratic process. They convinced Congress this was a bad idea. They tried again in 2009, 2010, and they failed in Congress. Again, kudos to them for trying. But bringing a challenge to the Supreme Court, that's not good for America. And it's frankly disappointing. It's disappointing that they did it. It's disappointing that the state attorney general did it, state attorneys general did it. And it's disappointing that the Supreme Court spent so much time on it and repeated the kind of rhetoric we've been hearing over the last couple of years. We have a real problem here, and we should be talking about possible solutions.
You want to just go to questions, or
Yeah, we've only
we're
got
running
15
short?
minutes
Yeah,
left.
yeah.
So we've got a couple of questions submitted online, as you saw in the poster. The first one is, and this goes to both of you, can you please respond to the argument that one of the principal purposes of the Commerce Clause, as originally understood by the framers, was to deal with collective action problems faced by the states, such as those collective action problems that became apparent under the Articles of Confederation? It seems like PPACA is designed to resolve the collective actions problems faced by states in developing affordable and comprehensive healthcare systems. So the question here is, can we resolve any constitutional doubts by considering PPACA as falling under the Commerce Clause, given that it is designed to resolve a collective action problem faced by states that involves commerce?
Let me take this, because I think I think my answer is going to be the same as Greg's. I actually don't find that terribly convincing. I think that these are, I don't think that the health ills or the insurance ills of Connecticut significantly influence the health ills or insurance woes of Rhode Island. I don't think that this is a case of collective action between the states. Now, I do think that insurance pools are important. I'm sure Greg would agree with that. But the states are large enough where it doesn't really meaningfully implicate in an economic sense, in a collective action sense, or a free rider sense among states. I don't think it implicates that element of the Commerce Clause.
We have agreement. Here's a quick one. The government can force us to buy car insurance, so what's the trouble with health insurance?
Can force you to buy car
Insurance.
well, states can do that, clearly do that through their police power. If the federal government tried to do it, I'm not sure. I mean, as a condition on driving, maybe. What they can't force, the better question would be, can they force a resident of Manhattan to buy a car? I don't think so.
That'd be a really bad policy. The logic, I suppose, is that the federal government could require the purchase of health insurance, the purchase of car insurance as a condition to getting a driver's license. The whole idea is that they are now voluntarily engaging in commerce, but that illustrates the silliness of the distinction. Because needless to say, whether someone decides to drive or not, they are deeply affected by this kind of regulation. But the question raises a really important idea. All states thoroughly, and I've actually written too thoroughly, regulate auto insurance, the purchase and rates of auto insurance. And there's a long history behind that. It's really worth looking at the history behind insurance regulation on the state level to understand why insurance is so thoroughly regulated. There are a lot of bad reasons for why we have insurance regulation to the degree we do now, but there are a lot of really good reasons. It's because insurance is a really complicated marketplace. It imposes or creates all sorts of market failures that really beg regulatory solutions.
Congress could certainly say you must have insurance if you buy a car. That's prescribing the rules for carrying on commerce in the car market. But that's very different from a free-floating duty imposed on everyone to buy cars, and equally different from a free-floating legal duty imposed on everyone to buy insurance, regardless of whether they buy a car. I don't think Congress could do that.
Yes. I want to thank both of you. I'm not a lawyer, and not even a law student. But I do have a master's in sociology from this fine institution, and I work at a health services research center down the road, so unfortunately I was forced to wear this cap today. The question I have is, actually, I think that we should have socialized medicine, not what they just call socialized medicine, because I've seen people, given the current state of our healthcare system, die. And I know people personally who have done that. But I do have a question. Did Scalia really say, this is reported that he said, that this is the most intrusive thing the government has ever done or ever intended, ever could do? Did he really say that? And if he did, I'm a stand-up comedian also. Was he kidding? I mean, I was subject to the draft when I was younger. I'm going to be paying taxes soon. I'm going to be pretty soon on Medicare. Did he really say that? And so what was the context? And was he kidding?
He did say something like that. I don't have a direct quote. I don't think it's an unfair observation that this 2,700-page statute imposes very significant constraints on the freedom of individuals who are subject to the individual mandate, the companies that are subject to the employer requirement. You have to buy a minimum level of insurance. You can't buy more than the maximum level of insurance. This is a degree of government control over how people get health care that's far beyond what we've seen in Medicare or Medicaid.
Close to Professor Richmond. The debate between you seems to be sort of like two different paths in the night. I think Mr. Cassis seems to be talking about the next law that the Congress will pass, while you've been talking about the policy implications of this law. Is the debate really so focused when we're looking at Congress's capacity as an organ of the government with limited powers? We're looking at what they can do in any given situation, as opposed to the analysis training on whether or not this is just too complicated for the court to discuss. Isn't it a part of the court's duty to review whether or not Congress is exercising its limited power? And in that sense, how would you engage the arguments that Mr. Cassis has presented?
Is the court's duty? I mean, only if it does a good job of it, right? If the court were serious about looking at about enforcing limitations on Congress's power, then it would look at Congress's regulatory effects on the marketplace, and it would look at it in a very sober way. It would look at not things like force or taxes versus penalties or activity versus inactivity, none of which really have any meaningful bearing on individual behavior. They would look at things like whether there's competition, whether rates, insurance rates or prices fluctuate within the political economy envisioned by the framers. They would look at the effect of government ownership of certain facilities. I mean, one reason that these histrionics are so silly is because this is still a market-based approach to health insurance. And it's a market-based approach that all the other OECD nations have abandoned. This is a very market-oriented approach to healthcare policy. And if Congress were really, if the Supreme Court were really serious about meaningful limitation on congressional power, then it would look at the effects of the regulations, affect legislation functionally, with open eyes, and not looking at these silly ideological turns of phrases.
Couple thoughts. One, it's entirely common for the Supreme Court to think not simply about the case before it, but the implications of the rule that it's being asked to adopt. We have argued from the beginning of the case that one of the problems with the government's position is there is no judicially enforceable limiting principle to allow this sort of thing for health care or health insurance and not many, if not all, other markets. The Solicitor General was asked very directly the question, what is your limiting principle? And he didn't have a very good answer. I think that's because there is no very good answer. It seems to me that's an entirely fair consideration for the court to address. Now, on the question of effects, whether the court should impose limiting principles by virtue of effects, that seems to me, first of all, it's not really well grounded in law. The question is what counts as a regulation of interstate commerce. It's not something that the courts seem particularly good at doing, and it's not something that would really cabin Congress's power very much. So go back to Morrison, the Violence Against Women Act case. There was a legislative record. There was evidence upon evidence upon evidence of all of the impacts on interstate commerce from the aggregate effect of gender-based violence. If you were to just sort of focus on effects, does that conduct substantially affect interstate commerce? That case should have come out the other way. I don't know. Maybe that's an argument that it should, but there are all sorts of things that substantially affect interstate commerce in the aggregate. That won't cabin Congress, and it won't plausibly limit them to regulation of interstate commerce, which is all they're supposed to be doing. One final point, the fact that Congress has other means of providing health care to the needy seems to me cuts in favor of our theory, not against us. People say, well, what's the difference? They could just enact a tax, raise revenue, use that revenue to give health care to the needy. That's typically the way we provide public goods and services, and the fact that Congress can do that, as it has done with Medicare and Medicaid. Look, I may not like those programs as a policy matter, but I can't credibly say they're unconstitutional under modern doctrine. So Congress can do that through time-honored means to the extent we want more free health care for needy people. It doesn't need to cross this Rubicon of forced purchase mandates, which is very novel and seems very hard to cabin. So that all seems to cut it in favor of our theory, not against it.
One real quick thing. I have an answer for what is the limitation. What is the outermost place? Where is the point where Congress power ends? The answer, Wickard versus Filburn. Nothing beyond that, Your Honor.
This is beyond that. Filburn's neighbors didn't have to buy his wheat.
In the back.
I'm also not a lawyer and probably a parent of a child about this age and these kids coming up. It's a different issue when you get to be our age, and I totally agree that this is a huge issue. I've spent 7 years intimately involved with the health care. But you both give me lots to think about. And the issue I'm going to go to is the forcing, lots of issues there. But and maybe it's not a law, but every emergency room I've been to, which is 5 different ones, Carolina, Georgia, South Carolina, they all have to, or maybe it's a policy and not a law, but is there a law that says they have to treat the person that comes in? Isn't that forcing someone else into the marketplace?
There are laws. There is a federal law that is structured not as an absolute requirement, but as a condition on getting federal funds. If the hospital accepts federal money, they must make the services available. There probably are state laws. Most states have laws like that. So I think the short answer to your question is probably there are such laws.
Would you seek to abolish? I mean, I know this sounds terrible, but if you're not going to, if you're the forcing issue, then I think you've got to turn people away from the emergency. I mean, you can't force the hospital if you don't force the participant. If you're forcing.
In Commerce Clause terms, just on the constitutional issue, there's a huge difference between forcing someone to operate a hospital, which would be the supply side equivalent of this mandate, which is forcing people to buy goods and services, that would be very problematic versus what they are doing, which is saying, if you operate the hospital, if you are engaged in supplying medical emergency services to people, here are the rules for that commerce. Prescribing the rules for carrying on commerce. Court has said for 200 years that kind of thing is okay, but forcing someone to open up a hospital would not be, and that's the analogy to what we have here. Now, on your policy question, I don't know. I suspect there are ways of making sure that people can get emergency room care and doctors aren't left holding all of the bill, but I'm not a policy guy. I'll leave that to our policy expert.
Well, I will make 2 points, and both of them are very, very important points. The only kind of points I make. Yeah. One is this. There are laws, both federal and state, that require emergency rooms to be open to whoever comes. However, if you take away those laws, as a factual matter, before those laws were passed, emergency rooms still couldn't refuse people. You had the common carrier, common law doctrine. Essentially, you can't have your door there and close it to people who can't pay if they're in need. And this is not a doctrine that was a creation in 19th century England. This is about 1,000 years old. We have a one millennia old tradition of making sure that centers for emergency care are open for people who are in emergencies. Now, that's 1,000 years. It's a long time. It's not so easy to simply opt out of the national health care system by saying, well, I don't want to purchase insurance and I'm not going to go to the emergency room. That's not the world of medicine that we've all had for 1,000 years. With that moral and legal principle, it is quite obvious that we're all in the system and cannot get out of the system. Second point, I really want to hear from the challengers of PPACA an alternative. Some people think that, as you suggest, an alternative would be you really take away the government's role everywhere, including EMTALA. This is the emergency treatment law. That you do not, that you really do allow individuals to opt out fully, in spite of the 1,000 years of us doing to the contrary. You really have an entire world of individual responsibility where you can remove yourself entirely from the regulatory tentacles of the government. That's possible. That might be the vision of health reform that they're articulating, but we haven't heard it. And we need to hear it. If NFIB is going to raise a constitutional challenge, they have to have a serious plan on the table. Maybe the Federal Society does also.
Do you want the last word, Mr. Katsas? Join me in thanking our... Oh, sorry, I cut you off.
Make health insurance available across state lines. That would probably increase competition, make it more affordable. The government can do all sorts of things to provide free care to people who need it and to go after people who irresponsibly consume services and don't pay for them. But that's a couple of steps and markets removed from what they're doing here.
We have the beginnings of a compromise.
Are you both done speaking? Okay. Join me in thanking our debaters.
Produced by Duke University. Online at duke.edu.